All right, hello Ace Journal paper. So today we're going to talk about the Supreme Court because this week you guys are going to participate in what is called a moot, well, it's actually a mini-moot trial. So we're going to learn a little bit of background information about the Supreme Court itself because a moot trial mimics a lot of how the Supreme Court functions. And we'll get into a little bit of why that is. But we're also going to get some background information about a very specific court case because it pertains to what you're going to be doing this week. So we begin with the Constitution. So Article 3, Section 1 of the Constitution is the place where the Supreme Court is established. I found a laser pointer, so I'm going to use that periodically throughout the presentation. But that is where the Supreme Court is established in our Constitution. It is very vague, so you can read it yourself. I'm not in the way. It looks like I'm in the way on my screen, but not on your screen. It just talks about how the Supreme Court is the highest court of the land, but it doesn't really give its purview of to what it controls. That actually didn't happen until later. So the Constitution was established, and then about 20 years after the Constitution was ratified, the Supreme Court was in a trial that's called Marbury v. Madison, and that is where they established that the Supreme Court is able to interpret the law and make changes to the law based on the Constitution. So essentially, they are the final arbiter of the law, and they establish that what laws are valid based on our Constitution and our country's precedents, and what laws are not. So that's the case that actually started it all, was Marbury v. Madison. And when you take AP government in 2 years, 3 years, 1 year, depending on where you are in your college journey, or high school journey, wow, you're not in college yet, you will learn much about Marbury v. Madison. So let's get some background information into the Supreme Court itself. So there are 9 members of the Supreme Court. Fun fact, there were originally 6 members of the Supreme Court. There are now 9. They consist of 1 Chief Justice and 8 Associate Justices. They are, for the most part, an appellate court, meaning any case that comes before the Supreme Court, not any, because there are some exceptions to it, but most cases that come before the Supreme Court are, in fact, cases that were tried in other courts, lower courts, before they got there. So a court will hear a case, someone will sue somebody, for instance, and they'll say, this person did wrong to me. A court will hear that trial. They will then make a judgment and a ruling. And then the Supreme Court will come into play after they've made their ruling and say whether that ruling was valid or not. Usually it goes to other courts before it gets to the Supreme Court. But the important part is that the Supreme Court normally hears things after the fact. So they don't actually have a jury. It is just the 9 members that make a decision while the 2 sides discuss their viewpoints on the law and whether it was applied correctly and all that kind of stuff, which you're going to get to experience here during this mini-moot court trial. Currently, our Supreme Court, consisting of 9 members, you can see the picture. I'm moving my head because, again, I'm in front of it on my screen, but you're not on yours. Chief Justice John Roberts sits there in the center. He is surrounded by Clarence Thomas on his left, or his right, our left. On the other side of him is Stephen Breyer, who's on his right, our right, his left. Next to Stephen Breyer is Justice Sonia Sotomayor. On the other side of Clarence Thomas is Samuel Alito. Kennedy was much earlier. Behind them, you have Justice Brett Kavanaugh. He's one of our new justices. Actually, nope, he's not the newest anymore. Next to Brett Kavanaugh, you have Eleanor Kagan. On the other side of Eleanor Kagan, you have Neil Gorsuch. And then you have finally Justice Amy Coney Barrett, who is the newest or junior justice of the court. And they actually sit from the middle. They sit in their years of tenure. So it kind of goes outward, who is the longest serving judges, but the Chief Justice sits in the center, even though he's not the longest serving. I forgot I had a laser pointer and I could have just showed you them. So this is John Roberts, Clarence Thomas, Alito, Breyer, Sotomayor, Coney Barrett, Gorsuch, Kagan, and Brett Kavanaugh. All right, moving forward. So how the Supreme Court decisions are made. So what normally happens is, again, like I said, they're heard in a court case prior to being the Supreme Court. So a judge or court of some type, a lower court, an appellate court, a state court, they will sit and they will hear a case and they will make a decision. Then the person who is the petitioner, or they become the petitioner, will then bring it to the court's attention. If 4 out of 9 justices agree to hear that case, then it will be put on the docket for the Supreme Court to hear. And that usually starts in October when they start listening to cases. There will then be oral arguments where two sides, the petitioner and the respondent, will have a chance to present the facts of the case. So the petitioner is the one that brought the case to the court. So they're the ones that either they were found guilty or they didn't like the way that the court below them came up with their ideas. So they're petitioning for the Supreme Court to overturn it. And the respondent is the person who is on the other side, who is trying to keep or uphold what was stated in the courts below the Supreme Court. During the oral arguments, what's really interesting is that you have time, your specific times to speak. I think it's about an hour each side, and they go back and forth. And during that time, the Supreme Court justices are able to interrupt with questions at any moment, and that it interferes with your time rather. So if they can ask you questions the entire time and you may not get to anything you planned on speaking about in your case, because they could just ask you questions over and over again. And the rule is that when a Supreme Court justice speaks, you cannot speak over them. And it actually goes by tenure. So if, let's say Eleanor Kagan, Justice Kagan, is speaking and John Roberts wants to speak, who's the Chief Justice, then Eleanor Kagan has to wait for Justice Roberts to finish, just out of respect for the tenure of the court and the precedent being set. But the same thing for the petitioner and the respondent. If a Supreme Court justice asks them a question, they have to answer the question. They can't just ignore it. They can't say, excuse me, you're interrupting me. They just have to listen to the questions and state the facts and do what they can do. After they have had their oral arguments, which if you've never listened to oral arguments, I highly recommend it. I find them very interesting. You might as well. Another fun fact, the Supreme Court does not allow cameras in the room. So therefore, you will only be able to ever hear the Supreme Court. You will never be able to see it unless you go live. And you can actually go sit live in the in the seats of the Supreme Court. There is an auditorium where you can actually listen to oral arguments and see them. But you cannot watch them on TV or anything because there are no cameras allowed in the court building. That's why most interpretations of what happens in the court are sketches, because you have sketch artists in the courtroom who are sketching the justices, but they are not able to take pictures of the justices or videotape. So once they have their oral arguments, then the justices will meet, and they have specific conference days where they meet as a court, and they discuss the case. They'll try to talk about their side, what they're thinking, and all of that, and try to sway the other members to come to their side. They will then ultimately come to a decision, and then they will post their decision. They will have, as we saw when we looked at Justice Ruth Bader Ginsburg way back when in October, they will have the opinion of the court. And then they will have anyone who's not in the same opinion will then dissent, and they will state their dissension, right? So we will learn that Justice Ruth Bader Ginsburg was the great dissenter. So she oftentimes did not align with what the court was at her time because there was different ideologies involved and things like that. So the dissent just states what the other side was thinking and why they couldn't agree with the courts. Sometimes people dissent with parts of it. Sometimes people dissent with the whole thing. There was a recent case, the case with Texas, in which Justice Sonia Sotomayor agreed with the court's ruling, but disagreed with parts of it. So she dissented to parts and not the full. That's just minutia that you guys don't necessarily need to know, but I'm a Supreme Court nerd, so I like to share as much information as possible, which you should know about me already. Once they've made a decision, though, that is the precedent. It has been set. So other courts will then take that and they will apply that to other cases that are similar. And they'll say, okay, so the Supreme Court said this here, and so therefore this is how we're going to rule on this case on this side. And that's an important part of the reason why people put so much pressure on the court ruling in one way, because they want the precedent to lean in the way that they want it to lean. So that was a large part of why the Texas case, the Texas abortion law that was recently discussed, the Supreme Court, and actually decided in the Supreme Court, was so important because it set a precedent for every other state and every other court on how they could rule on states making laws such as Texas. So again, it all starts though with a petitioner. So we are going to focus on the case of Tinker v. Des Moines. So this is a case that's involving freedom of speech within the classroom or within the schoolhouse. So we're going to get some background information about it, and then you guys are going to actually become either respondents, petitioners, or judges yourself in a mini-moot court. And moot court just means a moot trial is just an appellate, a mock trial for an appellate court, because mock trials normally are criminal trials. A moot court is normally appellate. So Tinker v. Des Moines, here are some facts about the case. Oh, I'm in the wrong slide here. So it happened in Des Moines, Iowa. So in Des Moines, there was a group of students, 5 students. I'm moving my head because, again, I'm blocking myself, but not you. There were 5 students who decided that they were going to not protest, but show their lack of support for the Vietnam War, which was at the time a big issue. Well, it was a big issue still now because it happened, but at the time it was a place of protest for a lot of individuals. So these 5 students decided they wanted to show their support for not being in Vietnam any longer, and so they decided they were going to wear black armbands to school, not say anything, not start shouting, not chanting, nothing. They were just going to wear simply a black armband on their arm, and that was simply it. They were going to take it to school, just walk around school with a black armband on there. Well, the school board of Des Moines, Iowa learned about this, and so they decided to make it a rule that students could not wear armbands in protest of the war. They didn't want them to do that, so they made it a rule across all schools within Des Moines, Iowa rather, that you could not wear an armband in protest. And so the students still followed through with their activity. So the principal, following the laws, the rules of the school board, which they're required to do, had to enforce the rules. So one student, John Tinker, wore his to school. He got to first period. They sent him to the principal. Actually, he walked straight to the principal's office, told him he was going to wear this. The principal said, well, here's what I have to do. They instantly sent him home, and he was suspended for about 6 days from school. His sister, who's also got through most of her school day, her last name was also Tinker, got through most of her school day, and then by the afternoon they discovered, or someone brought it to the attention of others, and they sent her home for suspension as well. She actually agreed to take her armband off. Her brother did not agree to take his off. That's why they sent him home. She agreed to take hers off and then did take it off. And then later on, they decided to still send her home and suspend her. So all that being said, the parents of Tinker and the other students felt that they were infringing upon the free speech of their students within the classroom or within the schoolhouse. And so therefore, they brought this case to the lower court, the U.S. Court of Appeals. The Court of Appeals upheld the decision of the school board, stating that yes, there's freedom of speech, but this went beyond the freedom of speech. Yeah, so that the rules were there, and that this was a disruption in the classroom environment. So some precedents that's important for you guys to make your decision, because that was the decision of the courts, the lower courts, not the decision of the Supreme Court. You'll get that decision later on, because I want you to make your own informed decisions. Some of the precedents that was used to make that decision, first, the First Amendment, right? So this is the precedent on the other side, or the petitioner in this case, that there's freedom of speech that is unabridged, that no matter what, the United States of America is a place where you can speak your mind and be heard, but there are some tongue-tied. There are some small instances where that is not allowed if it interrupts within someone's livelihood or it is disruptive of just everyday life. If it's forcing your views upon somebody else, that's also something that would infringe on others' freedom of speech or freedom to not have a speech, and therefore there are some ways that they can get around that. The other precedent involved is the 14th Amendment, and the 14th Amendment basically states that if there's a law that applies to the United States, a state cannot change that law. So if there is a law that one citizen of the United States is able to do, then all citizens in any state is able to do the same thing. The 14th Amendment is used a lot to take laws from other states and apply them in other areas. So things like gay marriage, when one state would allow it and the other state wouldn't, if there was no supreme law of the land, it gets a little iffy. So until the United States made laws like the Defense Against Marriage Act, DOMA as they called it, it was kind of a gray area. Like if I was married in Massachusetts, then I should be able to be married in Florida too. So until the United States Supreme Court steps in, or until the federal law makes a law, it gets a little gray area. So the 14th Amendment is used oftentimes to make those decisions and say, well, if one citizen has this rule, then every citizen who resides shall also have that rule. It's kind of the makes everyone equal in all the states kind of deal. It's a little bit more complicated than that, but that's the simple version. And the final Precedent set was a previous Supreme Court decision that happened in 1943 called West Virginia State Board of Education v. Barnett. I had to read it because I forgot the name often. But essentially in that case, it was students saluting the flag. So it was a requirement that students had to come in the building of school and salute the flag every day. In West Virginia, that was the state that this was happening in. Well, there were students that were Jehovah's Witnesses, and a Jehovah's Witness basically won't their allegiance is purely in God, and so they don't do anything that would make it seem like their allegiance is not to God. So even they hold God above country. So therefore, they can't salute the flag because that would be holding the country to a higher regard. So they don't do that. Same thing, like they won't recite the pledge. They don't celebrate any holidays and things like that because they feel that their energies should be devoted only to God, and that's it. And so they told the school that they didn't feel like they should salute the flag. They brought it to a court case. They brought it to the Supreme Court, and the Supreme Court made the decision that, yes, they had that freedom of religion, and therefore we can't require them to salute the flag. So that was other precedents that was used in Tinker v. Des Moines to make their ultimate decision. There's the flag too, so you guys can see they were saluting the flag, and that's what they were protesting. And this is the West Virginia State House. So the issue you are going to be dealing with, and I'll give you more specifics in the classroom, is does a prohibition against the wearing of armbands in school, public school, as a form of symbolic speech violate the student's freedom of speech protections guaranteed by the First Amendment? That is the question that you are going to research and that you are going to argue in your mini-moot trials. So have fun, enjoy, see you in the classroom.